Good evening, everyone. I feel delighted to welcome you all for BEAM's first year anniversary webinar. I thank each and everyone for taking time out and being here on this knowledge sharing session. I'm Taslima Nasrin, a part of the managing committee and continuous professional development team at Bureau for the Empowerment of Arbitration and Mediation, BEAM, a non-profit organization based in Coimbatore, Tamil Nadu. Before beginning with, I would like to share some important points to be noted for the participants. Once your webinar is live, all the participants are requested to mute your audio and video. Please use raise hand option to ask your questions to the speaker, and also the participants can post your questions in the questions tab during the Q&A session. Kindly refresh your browser window if you face any audio or video interruptions. Participants who attend the entire session will be awarded with a participation certificate. Now I would like to discuss briefly about our organization, BEAM, and its objectives. A group of like-minded arbitration professionals and law students motivated to form this unique forum for arbitration and mediation. The main objectives of our forum are to foster institutional arbitration in Tier 2 cities and beyond, to create awareness among the general public, and to provide training to both the legal and allied professionals, to emerge as a bridge between the government law colleges and the arbitration fraternity in imparting the contemporary knowledge to the students, to regularly conduct continuous professional development sessions for the benefits of the students, to create awareness about the alternative dispute resolution, especially arbitration and mediation, regularly conduct seminars and webinars for the law students and the industry professionals, to establish an arbitration institution that is accredited by the proposed Arbitration Council of India, and to empower the budding lawyers into efficient arbitration professions. Once again, I welcome you all to this wonderful session. Now, without further commotion, we will turn the time over to our moderator, Ms. 𝗠𝗿, who is a managing committee member at Bureau for the Empowerment of Arbitration and Mediation, to introduce our speaker. Over to you, Ms. 𝗠𝗿.
Thank you, Taslima, for your wonderful welcome address. Good evening, everyone. Once again, warmly welcome you all for this webinar by our forum on arbitration is no more alternative, rather it is a preferred method. It is a great honor for me to introduce and welcome our chief guest this evening. The session will be inaugurated by Justice S. Ravishankar, Honorable District Judge Thirunelveli, who completed his graduation in Madras Law College in 1994. Then pursued Masters in International Law in Madras University and MPhil and PhD in Jawaharlal Nehru University, New Delhi, and then practiced as an advocate under the senior Lakshmanan and Sundaresan. In 2003, he cleared the magistrate exam in his first attempt and then selected as a junior divisional judicial officer in the same year. Thereafter, appointed as a judge in district court, at present Justice Ravishankar sir, serving justice in District Court, Thirunelveli. With this, I welcome Justice Ravishankar sir to inaugurate the session.
Thank you, 𝗠𝗿.
Thank you, sir.
Respected Sir Balasubramanian sir,
Yes, sir.
and the other participants, Mr. Ram, Advocate, Tariq, Talisman, Karthikeyan, many are here. Good evening to everyone. I also thank the Bureau of the Empowerment, especially this for making me to participate in this webinar on arbitration. Today, the topic and discussion is specifically dominated to be on arbitration. That is, arbitration is no more alternative, rather it's a preferred method. So I have an immense pleasure to share on this. This is actually supposed to be a dry subject for the law college students, but for the businessmen and practicing advocates on arbitration, it's very lucrative and it's very interesting. But as a law students, it's a very dry subject. Many of them may not enjoy. But if you go into the deep, how this ADR system came into being. It was all in 114th Law Commission report on Gram Nyayalaya. That is in the year 1986. The Law Commission of India examined that the judicial system suffers from inordinate delays, excessive cost, legal technicalities, and even uncertainty of judicial decisions. the task of solving the problems of background pending cases. So the Law Commission recommended setting up a forum designated as Grama Nyayalaya to resolve certain categories of civil disputes, particularly property disputes, family disputes in rural areas within the purview of judicial magistrates. The need for alternative they looked for, rather than a formal legal system which can be engaged, something like that. These are the basic attention that got into for alternative rather than a court system. And this was a concern for many judges, lawyers, and law researchers. Many, even decades of this was thinking was there. So, but this alternate dispute resolution system, this got fast-paced, took like a rocket from the emphasis of purpose of Section 89. And you all know, many of the lawyers here must be aware, others may not be aware, I don't know. The entire this ADR was first brought in emphasis
आवाज तेज है ठीक है
was reported in the year 2005-6 SEC, page 344. In that, Justice, Honorable Chief Justice, then Justice 𝗕𝗶𝗀 states like this: the challenge made to the constitutional validity of the amendments made to the Code of Civil Procedure by Amendment Act of 1999 and 2000 was rejected by this court in 𝗕𝗹𝘀 versus Union of India. But it was noticed in the judgment that modalities has to be formulated for the manner in which Section 89 of the Code, and for that matter, the other provision has to be introduced by way of amendment. So the first emphasis of this alternate dispute was emphasis in the 𝗕𝗹𝘀, and Section 89 got a wider connotation. And to have a brief look into this Section 89 is very essential. Section 89 of the CPC Code states where it appears for the court that there exists an element of settlement which may be acceptable to the parties. The court shall formulate the terms of settlement and give them the parties for their observation, and after receiving the observation, the parties and the court may formulate the terms if possible and send it for the various ADR method. For example, if the parties come to the terms of settlement, because they are better persons in what way they can settle themselves, and if the court also finds that there is an element of settlement, find out the element of settlement, where actually the knot between the parties are there, then refer this matter whichever available. Like if it is of arbitration, you send it for arbitration; conciliation, you send it for conciliation; or judicial settlement, or lok adalat, mediation, whichever the alternate dispute, you can send it. But identifying the problem, the element of settlement, that is the crux point. For arbitration and conciliation, the provisions of Arbitration and Conciliation Act to apply. For the core, for lok adalat, the court refers the same to lok adalat in accordance with the provisions of the Legal Services Authority. Judicial settlement, as far as not much developed in this country, but it may be come up in future. As far as the mediation is concerned, now a lot of mediators has been trained up by the Honorable High Courts, and even the Taluk courts and district court, a lot of have mediators thereby, and the matters can be referred. And the recent development is sitting judge mediators has also been appointed. And in Thirunelveli district, I am one of the judge mediator. And soon we'll be taking up cases on Saturdays and days and holidays to decide on the, like lok adalat and mediation is also a good process. But lok adalat we have a restricted, but in mediation it can be a continuous process. But in lok adalat, if you take up one case, if it has been settled, it will be sent back to the court. Again, it not be necessary that will be referred back again for negotiation. Whereas in mediation, it's not like that. You'll have a continuous negotiation process. Again and again, parties can come, fix a date, and they can sit. In that mediation, it's a wider concept, more authoritative is arbitration. And many, the expenses are very reduced. And the ADR, alternate dispute resolution, is speedy. You can get the results faster. The results also can be kept confidential. And the results, the parties themselves, they take. Party participants permitted by the litigant. ADR allows the parties to opportunity to tell their side of story. They can tell all the, it may not be in written form, all their grievances. If two companies sit for negotiation, they will tell all the backlog stories, what all earlier happened. So, if everyone pour out their own problems, both the parties, settlement will come. But if in a court of forum, both will tell the petition counter. The problem only 10% reflect on paper, black and white. Whereas they sit together, there will be a lot of other problems that can come in, even for family matters. Because in a family matter for divorce, you should need a torture. So torture, they will say physical abuse, this, that, and all. But actually, you sit with the parties and say, nothing put in this paper will be there because this will be prepared by an advocate. So it will be like to satisfy the court, the averments will be filled up. But whereas there will be minute tribal matter between them, which she may not like it, which he may not like it, and they would have come up to the court for divorce. So this sitting together and talking over is before a mediator or a neutral person, it will be a lot of helpful for the parties because they take part in the decision making. That is the importance of ADR because the party upon whom the decisions are made and they themselves participate in the taking decisions. For example, 1 lakh check amount is there or amount has to be given. If they negotiate, they can come to 70,000 or 60,000, they can agree. Both parties will agree. You will say, okay, I will agree. But if the same check case is done before a magistrate court, magistrate cannot give this decision. Or instead of 1 lakh, you give 60,000, he can't give. So the ADR have such a strong points like this that the parties, but how far it has been useful. And there also, I also like, there are some weak points also in ADR. As far this is a very wider subject, many topics can be included in ADRs, like business dispute, property, land, family disputes, consumer, landlord-tenant disputes, personal, all these things. But this may not applicable. All these factors which are can be brought in for ADR, alternate dispute cannot be for arbitration. Arbitration may be very restricted because today's topic is on arbitration as an alternative. There are some disadvantage also in the ADRs. There is no guarantee that continuous negotiation will give you a solution. Whereas in a court of forum, definitely one day a judgment will come and you will have an endpoint to litigation. But here, but there is an exception also. That in arbitration you have this guaranteed solution. Whereas in other mode of alternate ADRs, you cannot have that. In present scenario, local adalt mediation are having wider court connection and court is referring. Whereas arbitration, they should be having a separate arbitration classes and arbitration separately is dealt with. It may not come to the court because before coming to the court, they used to sit there. So I don't go into details of mediation. Mediation is a voluntary party take parts. All these things I have just told. It's all anyone can see. And in mediation, any settlement reached is also can be put into writing and signed by the concerned parties. And they can, similarly, if any award passed in local, that becomes final. It cannot be appealable. Once a decision taken in local and the jury members sign the papers, in presence of both the parties and the advocates, that becomes final, unappealable. You can't appeal against that. So local also having some many advantages that, but the local mediation and all, it is not compulsory that it has been. The concerned parties are not mandated. Without the consent of the parties, the court will refer for mediation. Even before the consent, without consent of the party, local adalta. But it's not like with others. So, so I have briefly told about the mediation and the other things. Now let me brief about today's highlighted topic, that is on arbitration. Arbitration is a quasi-judicial adjudicatory process where the arbitrators appointed by the court or by the parties decide the dispute between the parties. Procedure and decisions are governed, restricted and controlled by the provisions of the Act, that is Arbitration Conciliation Act. The award in an arbitration is binding on the parties. The adversarial in nature has focus on determining the rights and liabilities of the parties. Personal appearance is or active participation of the parties is not necessary. Always required in the bar. You can send your advocate to the arbitration. You can send your manager. He will talk on you. Not necessarily the parties themselves as you present them. Someone has to put forth your contentions, and you will have a time fixed by yourself. At what time you can come, you can participate in the arbitration. You can fix a convenient time. You can sit together in a good AC room and nicely talk and come to your decision. So arbitration has a lot of flexibility also. It's a formal proceeding held in a private strict procedure, nothing is there. Award subject to change of specific grounds and all. There is no opportunity for parties to communicate directly with each other. That is one thing is that. Once you come for arbitration, you got to speak only before the arbitrator. You cannot, after going out, you cannot have a separate, but a lot of people do that. That's why the arbitration doesn't come in. Because again, when they sit, they will say, yesterday I talked to the phone, he agreed for this, now he is not agreeing for this, like that. That it should not be there. And everyone knows that, and all the speakers are there, they will tell about arbitration, it's more flexible, and you can yourself, the parties themselves can select the arbitrator and the mediator. And typically selecting someone with expertise in the substantive subject, the field involved in the dispute. The arbitrator, the panel members need not even be an attorney. They can be well versed in the subject. In this way, the focus can be on the substantial issues involved between the parties. And the technical rules cannot be much importance. In normal litigation, the parties cannot select the judge. Whereas in an arbitration, you can select the person who is going to negotiate between you and conduct the arbitration. So the damage award or basis sold on both the parties and other things, and all the things I think you have speakers there. Mr. 𝗕𝗏 will deal. Now, arbitrary decisions are final. That you should keep in mind that. Very few exceptions, the decisions of a neutral arbitrator cannot be appealed, with fraud being an obvious exception, except on that ground that the arbitrator behaved or conducted the proceedings in an fraud manner or in a biased manner. Like that, other than that, you can't appeal the award. Another ground for setting aside the award is also arbitrary decisions exceed the scope of arbitration, the class of agreement. Suppose the limitations are there is a limitations, then the arbitrator can't go beyond that. If the dispute is for only 1 lakh, he can only decide on 1 lakh. All of a sudden, he can ask for 1 crore to be paid. So there are decision of the court, all these things they're there. Arbitrators can only resolve disputes that involve money and classes which involve the companies. They cannot issue or compel parties to do something this more than what actually. And fee for the neutrality or very charges and all should be minimal compared to the hiring a high-end advocate to conduct the case. Often the contract of the dispute contain broadly and mandatory arbitration classes. They may not have choice. For example, certain mandatory arbitration provisions has to do operating agreements and other types of business contracts. Unless both parties waive the arbitration, most states will compel to the arbitration to request any party. So hence, the agreement between the party itself should be enforceable one. If the agreement with the parties are unenforceable, the arbitrator also cannot do anything. Sometimes the court may order non-binding or judicial arbitration. This means that if a party is not satisfied with the decision of the arbitrator, they can file the request of the trial with the court within a specific time period. If you're not satisfied with the arbitration award, then you can ask, we will conduct the trial in the court and specific time period arbitration. Depending on the process order, if the party does not receive a more favorable result at the trial, they may have to pay a penalty or fees to the other side. That is also there. And the parties perusing ADR must be careful not to let the statute of the limitation run while dispute in ADR. Once the statute expires, judicial remedy also will expire. It will also, they will not available to them. So I think I have taken my time. And fine, I like to conclude here that there is no single answer as to whether litigation or ADR for the parties. Whether I can go and contest the case in the party or ADR. So the circumstances of each case need to be weighed, whether carefully analyzed by all both the parties and the advocates, everyone concerned, all the stakeholders. The stakeholders to decide whether we can take this matter, this dispute between them, to a ADR, whether we can go for any mediation or arbitration. This can be done considering the advantage and disadvantage of each proposed areas, whether mediation or things, and discuss on trusted and experienced legal. This is where you got the legal fraternity come, the advocates and lawyers. They can give a good suggestions. Company lawyers. Yes, if you take this matter to the court, it will take long time to solve the dispute. So let's go for an arbitration or let's seek for a mediation. So I hope I have run over the time now. I thank the organizers, in particular 𝗕𝗏 of Coimbatore, the moderators, and the Bureau of the Empowerment and the Arbitration Mediation is in Coimbatore for giving me this opportunity to speak on this topic, especially to the present complex commercial world. Arbitration is one of the finest methods for the complex commercial agreements. Commerce is growing in India, and it is said to be in another 5 years, we will be double the GDP. So in such a scenario, when business grows, arbitration will have a big foot and it will have a big say in solving the dispute. And Mr. 𝗕𝗏 would know that rather than going to the court, using this type of alternative method in industrial solving disputes, solving the problems, especially even for employer and employee, awarding, you can use arbitration. It will be good. A lot of cases will get reduced. I think I have a brief, given a brief insight about our ideas and arbitration. Thank you for the opportunity. Thank you, one and all.
Thank you, sir. Thank you for the inaugural address. Now, felicitation speech will be given by Mr. 𝗧𝗿𝗀𝘀𝗵𝗵, the President, Indian Chamber of Commerce and Industry, Coimbatore. He had his graduation in PhD College of Arts and Science, Coimbatore. Later on, started a paper business under the name 𝗕𝗹𝗀𝗶𝗶. He was involved in association activities since 1985 and Vice President, Indian Chamber of Commerce and Industry between 2016 to 2020. He also represented associates such as FTAC and Chamber of Commerce in various district and state level committees. Sri Balasubrahmanian has been awarded 𝗕𝗏𝗀𝗃 𝗀𝗏 Award, Sri Jayanti Raja Award, and many more. And a very important role here I want to mention is he is the member of MSME Facilitation Council. With this, without much ado, I invite Sri Balasubrahmanian sir to give felicitation speech. Welcome, sir. So please unmute your.
Thank you, Ms. Soundarya, for your nice words. Respected Sri Ravi Shankar sir, Honorable District Judge Thirunelveli, Sri 𝗕𝗹𝗀𝗃, Principal Associate Advani and Co, New Delhi, members of the BEAM team, all other distinguished invitees, participants, ladies and gentlemen, good evening to all of you. On behalf of Indian Chamber of Commerce Industry, Coimbatore, let me at the outset thank the organizers for giving me an opportunity to address this seminar. We are privileged and honored with the presence of the Honorable District Judge Thirunelveli, who made it possible to grace this occasion in spite of his busy schedules. Thank you very much, sir. Your excellent thought-provoking address, inaugural speech was very informative. Almost the whole arbitration in a very short time. You have covered the whole arbitration process. Thank you very much, sir. Arbitration, as rightly said, is preferred method to resolve disputes. It is one of the more frequently used ADR processes. There are numerous advantages to arbitrate as a way to resolve the case. Arbitration usually less expensive. That is the major advantage in this. Less expensive in terms of money and in terms of time. Though arbitration is very useful for solving disputes, careful consideration has to be given to whether it is applicable to or preferable in a particular dispute. That has to be taken care. There are some plus points that unlike trial, arbitration is essentially a private procedure. So that if the parties desire privacy, then the dispute, then the resolution can be kept confidential also. Under the traditional arbitration model, parties voluntarily participate in the arbitration process. I feel proud that BEAM is doing excellent and commendable job, and they celebrate their first anniversary today. It's a great privilege for me to be here with you. We in our Chamber of Commerce facilitate our members in the ease of doing business during the respective business processes. We are fully understand the role of the dispute resolution in the ease of doing business. In that aspect, awareness creation about alternative dispute resolution, especially arbitration, is the need of the hour in the two-tier cities. BEAM plays a vital role in linking the arbitration professionals and the academic fraternity. I am sure they will make a mark not only in this region but pan-India and overseas in the near future. On behalf of the Indian Chamber of Commerce Industry, we suggest BEAM to conduct training programs for every industry people in the regional languages. This way, they can reach out to the many stakeholders who are really in need of the remedy for the disputes via arbitration. I further emphasize the team to work on affordable arbitration such as MSME Facilitation Council that will really help businesses here in Coimbatore and other two-tier cities. Our chamber is given the representation in MSME Council and conduct meetings virtually, inviting both the parties to discuss and solve their problems then and there. It's a Tamil Nadu government process. I am one of the members in that MSME Council, Facilitation Council. We are having that on Tuesday. We are having the sitting for this month. Almost 100 cases are listed. I hope we usually around 25 to 30 cases are settled on that day, and few cases are adjourned, few cases are withdrawn. So in that way, it's a very good process, which is very much useful to the industry, particularly MSME. I request the judiciary to support BEAM's initiatives, which only complements an easy and quick dispute resolution. Indian Chamber of Commerce Industry assures all support and guidance to the team of BEAM in their endeavors. I also eagerly await to listen the keynote address by Sri 𝗕𝗹𝗀𝗃. With these few words, I once again thank the organizers for giving me an excellent opportunity today. Thank you.
Thank you. Thank you so much, sir, for your words and your continuous support. Now I invite my colleague, Ms. Geethanjali, Executive Committee Member Wien, to welcome our featured speaker.
Thank you, Soundarya. Warm greetings from Wien. I'm Geetanjali, and I'm honored to introduce our keynote speaker for the evening, Mr. 𝗧𝗃 Khan, an advocate of Delhi High Court and an expert in arbitration law. Mr. 𝗧𝗃 has many feathers in his crown. He has been enlisted in the Forbes Legal Power List 2020 as one of the top individual lawyers below 10 years of experience. He has been recognized as the youngest Business World Legal 40 under 40. Mr. 𝗧𝗃 has been featured in Fortune 500 magazine for his book, which is a bestseller, titled On the Rise. He has been recognized as an arbitration expert by SEC Online, qualified to the conference round of Judge Advocate General, Indian Army. Mr. 𝗧𝗃 is skilled in international and domestic arbitration, MSME disputes, writs, commercial, employment, insolvency, and bankruptcy law. He has been represented leading domestic players in high-stake project disputes. He is also a guest faculty in some of the prominent law schools of India. He has more than 50 publications in various journals, magazines, and popular legal news portals. Pointing out one of the many feathers in his crown, the topic for today's webinar, arbitration is no more alternative, rather, it is a preferred method, is itself a pick from one of Mr. 𝗧𝗃 Khan's work. A warm welcome, sir.
Thank you. Thank you very much for having me.
Thank you, sir. It is our pleasure. To start with, I would ask you, what was the reason or the idea behind your work, which is titled Arbitration is no more alternative, rather it is a preferred method, sir?
Thank you, everyone. Firstly, I'd like to congratulate you for this excellent initiative for promoting ADR as a mechanism, as a subject for dispute resolution. And I would like to thank my learned seniors for their patience and for such encouraging and golden words that they have shared with the immense experience that they have. Before I begin, answering this question raised by you, I would like to first go back, because I was hearing my learned judge who was pointing out about CPC and Section 89. I would just like to briefly touch upon, I'd like to take you back that where arbitration has come from. And, it's relevant to the answer that I have to give. If you trace back the history of arbitration, if I talk about the international history, some people may talk about the disputes of Salami between Megara and Greece, or where the father of Alexander the Great was deciding a dispute. And those Spartan judges who were deciding this dispute of island were also doing arbitration. But much, much before that, if you go, I would like to take you to biblical theory, that even in the Bible, the story of King Solomon, we all may have heard of that story where two ladies were fighting over a baby. One mother said, "It is my baby." The other one said, "It's my baby." So how King Solomon decided to adjudicate upon that dispute? He said that I'll cut the baby in two parts, and then you can keep one part for yourself. So the real mother, of course, said, no, I don't want this to happen. I want the baby to be given to the other woman. And that's how he decided the dispute. So it is said that that was one of the first few disputes, and King Solomon at that relevant time acted as an arbitrator. And the method he used was used as we know arbitration today. So arbitration has its origin since that time, since Bible. Now coming to the Indian history, a lot of you may know that 1940 Act was the first act when arbitration was recognized in India. Whereas I would like to take you back to 1772, the Bengal regulation. That was the first time arbitration was being used, but it was not that popular, that famous. So I'd like to take you to the Act of 1899, which was the first act of India dealing with arbitration primarily. And however, it was only extended to only 3 presidency towns. It was not extending to the whole of India, but that was British India. And thereafter, we saw in 1908, when CPC came, in Schedule 2, it was dedicated completely to arbitration, and Section 89 of the CPC was also dedicated to arbitration. And now, much later, in 1940, when the proper act came into the picture, and arbitration was recognized. So it repealed the Schedule 2 of the CPC and the previous act of 1899. But since 1940 Act also did not do justice to the act, and very rightly, Justice Desai raised his concern regarding the functioning of the 1940 Act, and the words which he used were very interesting. And the name of the case was Guru Nanak Foundation. I'd like to quote him. He said, "Interminable, time-consuming, complex, and expensive court procedures impelled jurists to search for an alternate forum, less formal, more effective, and speedy resolution of disputes, avoiding procedural claptraps, and this led them to bring Arbitration Act 1940. However, the way in which the proceedings under the Act have been taken and without exception challenged in the court of law has made lawyers laugh and legal philosophers weep. So this was the poor condition of the functioning of the Act of 1914, because there were too many delays and too much of judicial intervention, which was never the intent behind coming up with arbitration as a procedure, as a mechanism to resolve disputes. Now, in the 1990s, when the economic liberation happened, that is when India felt that, look, to attract investment, we would want to have a robust arbitration mechanism in the country. And therefore, they came up with a new act, which was the 1996 Act, the act which we, as we know today in arbitration in India, which has now been amended three times. One is in 2015, then 2019, and then 2021. So this is a brief history and evolution of arbitration in India, which I just thought I'll highlight. I know I'm going off the topic. Now, coming to your question, Gitanjali, which you very rightly asked me, why did I say that arbitration is no more an alternative to dispute resolution, and in fact it is a preferred method for dispute resolution? I feel, and I have a very major problem, that why arbitration is treated as a stepchild in India. Because unfortunately, litigation is given the preference over everything. And we have seen it's very common for arbitrators and lawyers to first finish their hearings in the court. And then, when they're mentally and physically exhausted, then they want to go for arbitrations. Most of the arbitrations you will see, unless it is an international arbitration or unless it is on a weekend, the arbitrations are starting after 4 o'clock, 3 o'clock, and then there's hardly any time left. That is my major concern, and that's why I feel that there was a time when arbitration was being treated as a stepchild, when in fact we all know the benefits it entails over litigation, like very rightly pointed by the speakers before me, including being less expensive. I would not say cheap. The right word used by Sir was less expensive. That's correct. And it is flexible. The most beautiful part and the beauty about arbitration is that no CPC and evidence strictly applicable. If you look at Section 19 of the Arbitration Act 1996, it says that the strict rules of evidence and CPC shall not apply to arbitrations. Now, this is the best part about arbitration. Another interesting aspect is that party autonomy, which means freedom of parties. Now, here, the parties are in charge. They decide how they want their dispute to be resolved, how they want to adjudicate it, and that's why I think arbitration is much, much more preferred over litigation. Another interesting aspect which the learned judge pointed initially is confidentiality, that anything which is happening in an arbitration proceeding is confidential. There's a difference between confidentiality and transparency, so I'm not going there. But in true sense, how it's implemented, I would not comment on that, because once the proceedings go before the court for a challenge in 34, in my view, confidentiality goes for a toss. So these are few, the good reasons why arbitration is doing great. And even if you look at the international perspective and how the investors are looking at it, I think they love arbitration as a dispute resolution mechanism. That's why we see in a lot of international contracts where investors are investing. If you look at BITs, bilateral investment treaties, they prefer going to arbitration rather than going to the Indian courts, because they do not have an excellent experience of dealing with Indian courts and how the matter was, taking forever to be decided. Because you know it, and I know it, that when a matter goes to the court of law, we do not know when it will be adjudicated. At least with arbitration after 2015, 23rd October, we realized that the time period has been reduced Firstly, it was 12 months plus 6. Now it is 6 plus 12 plus 6, which means that maximum it can be 24 months. We call it 18 months because 6 months is for completion of the pleadings, then 12 months for pronouncing an award. And if it cannot happen for some reason, then 6 months can be extended by consent of the party. So that's why I'm saying broadly 2 years. But in spite of all of this, you call arbitration an alternative dispute resolution mechanism. So that's my problem. Arbitration is the first choice. The government is pushing it. Judiciary is pushing it. The world wants it. International investors are liking and investing in India because of arbitration, and they want it to be more robust. So when that's the whole idea, and when you want to reduce the burden of judiciary, why do you call arbitration as an alternative? I think it's a preferred choice. People are no more happy going to the courts and resolving their disputes. Almost every contract that I'm opening, commercial contract at least, I mean, without even looking at it, I presume that there is an arbitration clause. So it's the first choice. I think people like dispute resolution by arbitration. So it's the only primary, and in times to come, it will be not just me. Let's just talk about Mr. Fali Nariman, who is probably the best person to answer this question. He himself said in one of the conferences in Delhi High Court when I was sitting, an event organized by Delhi International Arbitration Center, his opening remarks were, the future of arbitration is bright because the future of litigation is not. So when we're talking about all of this, so I think that's the thing why I feel that arbitration is no more an alternative. It is a preferred and the first choice for dispute resolution.
Thank you, sir. Your answer was not only interesting, but it was also true. Moving on to the next question, sir. Arbitration institution in tier 2 cities, are they sustainable, sir?
That's a very pertinent question. I'd like to answer this question in two limbs. Firstly, that my problem is that the focus of the government and all of us has only been on tier 1 cities. We only talk about Mumbai, Delhi, that's it. We have completely ignored the other cities. When we talk about arbitration, arbitration culture in Delhi and arbitration culture in Bombay. If you want to make India a hub of arbitration, then don't just focus on 2 cities. There are many more cities, and especially the tier 2 cities. I think there's a lot of potential, and we must emphasize and focus more on growing the arbitration culture in these cities. Now, the second question about institutional arbitration in these tier 2 cities, frankly, whether it is a tier 1 city or it's a tier 2 city, the problem is that we don't understand that arbitration center or arbitration does not become better by making a 5-star property. I have personally seen in Delhi, there was this arbitration center which turned out to be a big disappointment for many. It was better than all the other centers, perhaps. But the only problem is you need good administration. You need a good leader. If I give you example of Singapore International Arbitration Center, in last 10 years, it has grown to 300%. And all the Indian work is going to Singapore because of SIAC. So Singapore International Arbitration Center helped Singapore as a country in becoming the hub of arbitration. But what was the reason? The reason was simple, that the leadership, for instance, if you look at the leadership was Mr. 𝗕𝗏𝗀. I don't know how in India anybody will take out time, somebody like that will be willing to sacrifice his or her practice and, be dedicated to a cause and really promote arbitration in a center like that. Good leadership is what is required. I don't think fancy building is enough. People have this mindset, we'll make an international world-class building. Buildings will not make India the hub of arbitration. And yes, if there are honest efforts being put, if the initiative is being taken, like what you have taken today, I think these are some excellent initiatives. You have such good guests, predecessors, learned seniors who spoke before me. They're so learned. Their experience should actually be used and their input should be taken. In every city, we have such learned people. They should be involved. Young generation should be involved because most of the time, youngsters are completely ignored, whereas they are the torch bearers and they have to take it forward. So the flame will burn brighter only when the torch is in their keeping. So, I mean, that's the way I look at it.
Thank you, sir. I would completely agree with you. Moving on to the next question, if you could kindly brief about arbitration under MSMED Act, sir.
That's a very, very pertinent question, and that's very close to my heart because I've been doing MSME for a long time. And MSME, I started doing pretty long. It was one of the first few matters that I started taking was ME matters, because the arbitration, there was not much clarity and the position of law was never settled in the country. I wrote extensively on MSME because there was no jurisprudence at all on MSME. I've appeared, fortunately, across the country in various MSCFCs, and I've seen that there's not much clarity on the law. I can tell you certain issues, but right now you're asking me to explain the procedure, so I'll explain the procedure. Section 18 basically talks about a two-step mechanism, that if you are a micro, small, or medium enterprise, now the benefit is only to MS, which is micro and small. And earlier the criteria was based on the investment in machinery, but now the criteria is your turnover also. So what is the investment in the machinery plus the annual turnover? These two criteria will determine whether you are a micro or a small enterprise. You can simply go on the ODM web portal and you can register yourself there and you'll get a certificate. It's a self-registration, very smooth and very simple. Once you get this certificate, you just have to file a claim in any MSEFC where you're registered, because as per Section 18, the jurisdiction will be of that facilitation council where the supplier, that is you as a micro or small entity, is located. Even if the private contract which the parties have entered into may say that jurisdiction is Bombay, but if the micro or small entity is based in Coimbatore, then Coimbatore Facilitation Council will have jurisdiction. The reason is simple, because a private agreement entered into between parties cannot override the Act of Parliament. And GET&D judgment, Ranki judgment of Delhi High Court, all of them have clarified the law. Even Shilpi Industries recently, the landmark judgment as on date in Supreme Court, that has also clarified the law on the point. So the procedure is simple. When a reference is filed under Section 18, the first thing is that the conciliation itself takes up the conciliation proceedings. 90-day period is the time period for deciding every reference as per the MSME Act. But there is again ambiguity on that. I will not go on that. Then if conciliation fails, if parties do not settle the matter, then the matter is referred to arbitration. Now, interesting part is that even though 18.3, if you look at it, says that if conciliation fails, then the arbitration will begin. Now, most of the facilitation councils are themselves conducting arbitration. Now, the issue is, if you are a conciliation body, you cannot, as per law, take up the arbitration. But for some reason, the facilitation councils are doing it. And some of them are referring it to third parties, which is like some arbitration centers. Like in Delhi, they refer it to DIAC, and they are appointing independent arbitrators. Now, when arbitration starts, again, there is a glitch. In some places, the arbitrators are treating it as a proper arbitration under the Arbitration Act, and they are taking it for 1 year, whereas every reference under the Act has to be decided within a period of 90 days. So there's a lot of confusion. I wrote a representation. I don't know what happened to that, to the Honorable Ministry recently. But this is the mechanism. The interesting part about the MSME is that there is an interest component, that 3 times the bank rate interest you will get on the pending invoices, which is not usual. And the another privilege is, apart from that, the fact that in 90 days your dispute will be decided. That's how it's different from normal arbitration. If you are challenging any order of the MSME, then 75% amount has to be first deposited. So that's another privilege which MSMEs get. So I think these are some key factors why MSME is gaining popularity. And I think it's extremely important, for the benefit of these MSMEs, so that they don't become sick industries.
Thank you, sir, for the explained answer, detailed answer. Now we have a few questions to be addressed by Ms. 𝗠𝗿, sir. She has a few questions. Moving on to Ms. 𝗠𝗿.
Hello, sir. How arbitration can gain popularity among government law college students, sir?
Arbitration, I think, has already gained a lot of popularity, at least in our country. Students are, I've seen people very active on LinkedIn, and it is gaining popularity. But yes, if you really want to encourage in any college or any jurisdiction, the best way is awareness. You need to tell the benefits and perks that it has over litigation, and how you can actually help the society by promoting arbitration culture. And by carrying on these events, these kind of conferences, inviting guests, so that, they get to know and they get some kind of exposure. The other thing which we can do is open an arbitration cell or ADR center in our university or in our college. And we can, then obviously when there is a center, then you can probably provide these kind of services like legal aid clinics and all. And students will be encouraged. There'll be competitions pertaining to. So that ADR society, you will be able to identify which students are, inclined in pursuing a career in arbitration. And then you can take various initiatives and all. So I think that's the way to go forward, to encourage students really pursue arbitration as a career.
Yes, sir. Thank you. And my next question, as a budding lawyer, what will be my next immediate role in the area domain?
Sorry, I couldn't hear you. As a budding lawyer, what should be your next?
Immediate role, sir, in area domain.
So, as a budding lawyer, like two things. Either you're asking about your career, uh, if like young lawyers have doubt as to how they should grow, then what they can do is, if they're asking about themselves, they should join a firm which is doing arbitrations day and night, and or probably a lawyer who's doing arbitrations. Because only when you get into an office where arbitrations are happening, that is when you understand and you learn the nuances and what are the intricacies. Reading books, watching lectures will give you a broad idea, but unless you yourself experience it and personally do arbitrations day and night, read the volumes of documents, you will never get comfortable with arbitration as a subject. So the best practice to grow as a professional is to join an organization or an individual who is doing arbitration day and night. Now, other thing is, your obligation or your moral obligation as an enthusiast should be to generate awareness. What you can do is you can start writing on interesting topics if you want to grow and get recognition. Apart from that, you can perhaps organize events, participate in events, and take just initiatives like conferences, webinars, be a part of it, get connected, grow your network. These are a few things I think I'll recommend.
Thank you, sir. Definitely, we will follow your words. And my another question, sir, what are the best practice to be adopted to make arbitration robust in India?
I had written an article criticizing the fact, like, pointing out a lot of loopholes. But I think if we really want to make arbitration a hub of India, hub of arbitration, I think we need to first have a proper full-time arbitrators and full-time arbitration lawyers. Like I said, arbitration is treated like a step baby. That shouldn't be the case. There should be lawyers only dedicated full-time to arbitrations, so that they can give full attention and full, with a lot of dedication, they should only do arbitrations. And arbitrators also, they should be full-time. The other thing is that sloppy drafting of the law is the problem. We have seen so many absurd amendments which came and the issues were not addressed. If you look at the language was so confusing that, for instance, if you look at the 2015 amendment, it took Supreme Court 3 years in the case of BCCI versus Kochi Cricket Association to explain whether the amendment was prospective or retrospective. So if the amendment is not even clear, a lot of judicial time was spent on it, and many matters suffered because of it. So sloppy drafting of law must be avoided. Then the other issue is, we don't have an arbitration bar. I have been speaking and I've been super vocal about it, that you need to have an arbitration bar, because the normal bar association is only busy with addressing the issues of the courts. And what about the issues pertaining to arbitration? Nobody talks about it. Nobody raise any kind of concern about it. So I think we need a proper arbitration bar to address the issues pertaining to arbitration. Another thing is, I feel that we need to really give a positive message. The courts in India need to pass judgments, because a wrong precedent can take 10 to 15 years to correct. And the kind of damage that it may have, uh, we can't even imagine. So, it's very difficult for all the courts to be on the same line, all the high courts, so many high courts in India. But at least we need to have a pro-arbitration approach. And we really need to give a message to the investor community that, look, we are going to enforce awards. We are going to enforce agreements. Please invest. Don't worry. The other thing I think, which I'd like to address is that we keep changing law very frequently. After 2015 amendment, the 2019 amendment came, then 2021, which shows that, you have not done your homework properly. So I think these kind of issues, I think we can focus on, and perhaps that would make it better.
Yes, sir. Thank you for your answer. And my colleague Taslima want to continue the question, sir. Ms. Taslima?
Thank you, Soundarya. Good evening, sir. Sir, my question is that are litigation and arbitration converging in India?
That's a very interesting question. The thing is that arbitration has been become like litigation now, because the practice of appointing only retired judges is a very, very bad practice, I feel, because most of the arbitrators are not lenient. Some of the arbitrators I have seen, they are applying CPC and evidence very strictly, and they have made arbitration just like a trial court. Cross examination is going on for 10 days. Nobody's controlling the cross examination. So what they have failed to understand is that arbitration is not something like litigation. It is very different from litigation. It is more flexible, and the approach has to be different from what approach they were having when they were sitting as a judge in the court. So I personally feel that arbitration has become like a second litigation. It's just like the brother of litigation, and people have. But yes, there are some improvements, because if you see that every arbitration without any challenge, without any exception, was being challenged in the court, and for every small little thing you go to the court anyway. So arbitration and litigation are, if I'm doing arbitration, I'm going to the court every day. Why? For appointment of arbitrator, for challenging the award, for interim reliefs under Section 9, for substitution of an arbitrator under 1415, for appeals under 37. So the problem is that idea was to keep arbitration out of court, and to make it faster and better than the court system. But the problem is, for even an extension, you have to go to the court under 29A. So I think these are a few things which can be addressed and looked at, and court intervention, judicial intervention should be the least. Uh, so I think there should not be too much of interference and involvement.
Sir, we have a question from our audience, sir. One Mr. Sivaram and Rajendran. Is the place of arbitration still relevant in ODR?
See, in online ODR as such is not very prominent in India, and I've not seen a lot of ODR happening. But in my view, place would obviously make a difference, because if you are talking about virtual platforms, for instance, and not online dispute resolution, then even then it matters where you are. Parties will probably, but I mean, it can be conducted from anywhere. The beauty about ODR and all these artificial intelligence and virtual platforms is, but for challenging the award, or for probably for those purposes, for judicial intervention, you would require the place of arbitration, because only those courts will have jurisdiction. So that's my take on it.
Thank you, sir. Another person, Loganathan Gurumurthy. What is the role or contribution of subject matter expert in arbitration?
I think it's very important in arbitrations which are highly technical to have on board somebody who's a subject matter expert as an arbitrator. But it doesn't happen most of the times, because disputes relating to quantum, delays. So, but what you do is, if the arbitrator is not that an expert, then we have experts, external experts. As per Section 27, you can have an additional expert. Either the tribunal can appoint it, or a party can bring an expert of the subject matter to give testimony in the case, to assist the tribunal. So that's the way forward.
Thank you, sir. I have one more question. How the Indian courts have won the confidence of investors?
Indian courts have given some very positive judgment. I'll just tell you a few judgments. For instance, earlier the approach was really bad. ONGC saw pipes was a blunder. Bhatia was a blunder, due to which we really had to, investors really criticize these judgments. But then some new, if you look at the past few years, Justice Nariman has really shaped up the law and arbitration in India. He has passed some really good judgments and said that the scope of interference with the awards would be really, really less. Especially the 2015 amendment, wherein they said that in foreign arbitrations, the patent illegality will not be a ground for challenging an award. So that was another positive step to attract foreign investors, that we will not, interfere with the awards. Then Justice Indu Malhotra's judgment in Vedanta, wherein she enforced a foreign award That was very much appreciated by the foreign investor community. Another judgment, if we look at it, is hardy exploration, BCCI, as a Sangyong. So, limiting the scope of public policy, that's the right approach. That's the correct approach. Then the judgment in Shriram EPC, Rio Glass, when this was a judgment wherein they said that the foreign award need not be stamped in India. That was another positive move to show that Indian courts are actually welcoming investments and they're appreciating it. But a few things which have sent a negative signal is Vodafone, Kane, all these disputes which were challenged by the government for as a a rule. Even though Vodafone case, we all know the Supreme Court ruled in favor of Vodafone. Then there was a change in amendment. Finance Act was amended. The retrospective law came into the picture. So all of that was pretty, really disappointing for the investors. But this Amazon judgment was a very, very positive move recently by the Supreme Court. And I think that will send very positive signals.
Sir, another question is, what is the relevance of precedents in the arbitration proceedings?
So precedents, like that you cannot have arbitral tribunals precedent because every award is confidential. It cannot be used in any other tribunal. But if you talk about the judgments, they're as usual as precedents are used in the court. Similarly, you are using these precedents in arbitral tribunals also. The arbitrator is bound by those judgments and he has to follow, just like the courts. There's no difference.
Sir, one Mr. Ashutosh Singh wants to ask a question to you. Sir, you may please ask your question.
Am I audible?
Yes, very much.
Yeah, sir, good evening, sir.
Good evening.
So, although I have already asked this one on LinkedIn, but I think it is also relevant to the present agenda of this conversation. So, my question, so I have basically two questions. The first one is why the arbitration matter are confined only to the construction or infrastructure matters like engineering and other trunky projects. Why not other matters, which definitely implicate that it is preferred by only the infra developers only?
No. Answering your first question, sorry, Ashutosh. That's not correct. You're right. Most of the disputes are construction disputes, but if you want to read about arbitrability, almost, we have done designs also, damages, any matter pertaining to damages, somebody's contract was terminated, illegal termination, indemnities, all of these kinds of disputes are also arbitrable. It's just that there are a lot of construction disputes. So perhaps you may have read a lot of judgments in construction disputes where arbitration was there. And construction disputes is just one kind of an arbitration. There is bilateral investment treaties arbitration, there is sports arbitration, there is maritime arbitration, so much. So there are a lot of arbitration types. Yeah.
So, but this one is the dominating in arbitration matter.
You may say so.
Yeah. So, and I have a notion that to get familiar with construction and infra, we have to some kind of basic knowledge of physics and math up to the class 10th level.
Nothing like that. See, I was really afraid of maths. The minutiae of maths never interested me.
But sir, you did your 10+2 in science.
I appreciate that.
Yeah, but you are familiar with this kind of thing.
It's never useful, and I don't even remember what I read, and I was never interested in science. Unfortunately, I couldn't even clear my exams. That's why I did law, because I was scared of maths. But there's hardly any I don't see any applicability of maths or physics.
Like measurement of any kind of length.
Nothing. You don't have to do any of it. It's all done by the engineers. It's all on the record. And if at all there is a technical issue, then you can always engage experts. Lawyers never ever do these things.
Okay, sir. Thank you, sir.
Thank you.
Thank you, Ashutosh. Now I should propose the vote of thanks. Good evening, everyone here, distinguished speakers, respected dignitaries, and dear participants. On behalf of Bureau for the Empowerment of Arbitration and Mediation, I take this opportunity to propose vote of thanks. Once a great man whispered, feeling thankfulness and not expressing it is like wrapping a present and not giving it. Today, I take the opportunity to put all my gratitude into words. First and foremost, I thank our special guest, Mr. Ravi Shankar, Honorable Judge of District Court, Thirunelveli, who despite his busy schedule, honored this function with his inspirational thoughts. I also express my heartfelt thanks to Mr. 𝗕𝗹𝗀, the President ICCI Coimbatore. I thank him for his kindness, his interest, and continued support. I would like to thank our keynote speaker, Mr. 𝗧 Khan, Advocate, Delhi High Court, and arbitration law expert, for gracing today's webinar. Thank you, sir, for your thought-provoking words. Thank all the distinguished invitees present here accepting our invitation. Last but not the least, a big thanks to each one of you who made this event successful. Thank you, everyone. See you soon in our next webinar.